time, and I call the member for Warringah.
Thank you, Mr Deputy Speaker. I rise today to speak on the government-proposed Crimes Amendment strengthening the criminal justice response to Sexual Violence Bill 2024. A 2020 investigation by the ABC collected data on sexual assault in each state, territory and postcode, with the exception of the Northern Territory, who refused to provide the data to the ABC. And this data showed a dire situation, that more than 140,000 sexual assaults were reported to Australian police in the 10 years to 2017. But just under 42,600, or some 30% of sexual assault reports, led to an arrest, summons, formal caution or other legal action. The other 50,800 investigations, more than 35% of reported sexual assaults, remained unsolved. In New South Wales, only 1 in 10 reports since 2009 has led to legal action, and that's without even addressing how many do not report because they are so disillusioned with the system. It's clear, all levels of government, we are not doing enough on sexual assault and holding those responsible to account. It's just not good enough. Many in this place, in fact, were on lawns before the Parliament during the March for Justice and Enough movement in 2021. And it's clear that many people around Australia want to see this change. This bill is a good first step. It aims to address, in part, improving the experiences of victims of sexual assault within the criminal justice system. Many survivors of sexual assault have described the judicial process as a more traumatising than the initial violence. To change our legal and justice response to sexual assault, and in doing so inspire prevention, we must create confidence, consistency, accountability and transparency in the police and justice responses to reports of sexual assault. Now, we need a victim-centred approach within our judicial systems that promotes the safety of victims and rejects victim-blaming culture. And I can't raise that point without referring and considering the experience we have had from a previous staffer in this place. We can't talk about sexual assault and the process of that going through the courts without reflecting on the very high-profile Lehman prosecution and the vilification of the victim, in that case of Brittany Higgins, by multimedia outlets, by members in this place. And we still have not had an adequate answer as to how was it possible that materials produced under compulsion of court proceedings, under notice to produce or subpoenas, found their way onto the front page of media. There are questions in relation to review, in relation to the news exemptions under the Privacy Act, and whether our contempt of court laws are adequate to hold to account media outlets when they have such a breach of trust. There are serious questions that remain unanswered in relation to those proceedings, and they are questions that I am pursuing with the Attorney-General, because we must have a situation where complainants, victims, can have a level of confidence in the legal process and the court process when they bring forward their complaint. This bill goes some way to helping that. We also need to talk about police culture. The substance and the change of this bill, we need to address as well that there have been numerous reviews into police culture in various states and investigations by news outlets as well. Unfortunately, there is still a lot of work to be done. The 2022 Independent Commission of Inquiry into Queensland Police Service Responses to Domestic and Family Violence report found the following concerning the Queensland Police. And we must think about these findings in conjunction with just how many reports from victims do not lead to prosecutions, right? We have to think about the nexus between all these issues. That report found, despite the initial protestations of the Commissioner of Police and the President of the Police Union of Employees, the Commission has found clear evidence of a culture where attitudes of misogyny, sexism and racism are allowed to be expressed and at times acted upon, largely unchecked, where complaints in relation to such treatment are brushed aside or dealt with in the most minor of ways, and those who complain are the ones who are shunned and punished. It's hardly surprising that these attitudes are reflected then in the way that those police who hold them respond to victim survivors. It's a failure of the leadership of the organisation that this situation has been allowed to continue over so many years. A 2021 Sun Herald investigation uncovered allegations of inappropriate sexual behaviour by senior New South Wales police officers, and with these individuals often protected by a boys' club culture against internal complaints. An independent review of New South Wales Police by former Australian Sex Discrimination Commissioner Elizabeth Broderick in 2019 found that 1 in 3 women had reported sexual harassment by a colleague in the past 5 years. So within the context of such a culture within state police forces, whilst of course abhorrent, there's no doubt there's a flow-on effect into how police then properly handle, investigate and then pass or recommend prosecutions in relation to sexual and domestic violence cases. So whilst this bill doesn't deal with this directly, it must be highlighted that a wholesale culture change within Australia's law enforcement fraternity is required as part of the wider change to put victims of such horrible crimes at the heart of our investigation and justice system. This week I've been raising my grave concerns in relation and calls for greater action in relation to domestic violence. This is all linked. Our systems are not yet set up to protect victims of violence, and too often it is women. In my electorate of Warringah, caseworkers for Women and Children First meet women who have suffered from domestic violence for coffee in public spaces, so they have an easy excuse of why they're there. Why? Because so many are being tracked by technology. These organisations on the front line of domestic violence catastrophe in this country are trying to offer support and safety and advice. But too often there are concerns that there isn't enough support by law enforcement and then the justice system. For example, just last week, a client of that centre was asked through court proceedings, she is living in a refuge, had her location disclosed to the court by Medicare. Now, it was demanded by a dangerous perpetrator without any advance warning. So it shows how our justice system and our bureaucratic systems are simply not set up to protect victims of sexual assault and victims of domestic violence. So we have a lot of talk in this place, but we really need to start getting more action and, in particular, leadership from the top to ensure we have wholesale systemic changes across multiple levels of organisation. So this bill before us does create positive change, and I really commend the government and I urge them to continue working on bringing in more change. It aims to improve the experiences of victims of sexual assault within the criminal justice system. Specifically, it makes the following key changes. It expands protections for vulnerable persons and ensures that the special rules more comprehensively protect vulnerable persons. It makes the evidence of a vulnerable adult complainant's reputation with respect to sexual activities inadmissible in a vulnerable adult proceeding. It restricts the admissibility of sexual experience evidence of vulnerable adult complainants unless the court grants leave and considers specific criteria. The court must also have regard to whether the probative value of such evidence outweighs any distress, humiliation or embarrassment it might cause the vulnerable person. The bill also enables a court to order evidence recording hearings in proceedings involving vulnerable persons if it considered it's in the interest of justice to do so. The bill also sets out conditions regarding how the evidence recording hearing must be conducted. It introduces safeguards to protect recorded evidence given by vulnerable persons from misuse. And it requires a new requirement for the court to arrange an interpreter for vulnerable person to assist the person to understand and participate in the proceedings if they are unable to because of inadequate knowledge of English language or physical disability. And finally, the bill clarifies that the current restriction on publishing material that identifies or is likely to identify another person as a child witness, child complainant or vulnerable adult complainant in a proceeding does not apply to a vulnerable person who publishes self-identifying material. And this is important because our victim should not be restricted from being able to express. And we know, and that is really being highlighted more and more, just how important that is, that silencing victims adds to the trauma that they have already suffered. Now, we have to be cognizant of just how many and just the rates. It's impossible to even know the exact number where sexual assault survivors, such a small percentage, raise the complaint in the first place. They are fearful of going to the police. The treatment by the police often leads to a lot of questions. The lack of then proper investigation, and then the incredibly small percentage of ensuing prosecutions leads us to a situation where victims and survivors of sexual assault have so little trust and faith in the system and a reluctance to engage with it. That absolutely must change. So, and you can't, anyone who has been in this place over the last few years simply can't look at this question without reflecting on the treatment and the absolute, just the treatment in the media by an alleged victim in this place. So overall, this bill is a step in the right direction for a more victim-centred justice system for those who suffer the trauma of sexual assault. But I urge the government to remain open-minded on further reforms as needed, particularly to ensure greater streamlining between federal and state jurisdiction. A case that has been brought to my attention is where it goes across state lines, that often evidence prosecution falls through the crack for victims of sexual assault, in particular in the case of minors, and that sometimes may need to be considered from a Commonwealth federal jurisdiction, because going across those state lines often leads to the cases not proceeding to prosecution. So it's clear that this is an area we must do so much more. We must put the victim first, provide the adequate protections and support. And I know this is an ongoing situation where many members of Parliament, in particular anyone who attended the March for Justice rallies before Parliament, the tears that it was incredible. From women of all ages, of all race, colour, experience, financial demographic, in tears that finally there was some conversation about the experience and what they had survived. We simply can't stay silent on those issues. It's time we bring sexual assault to the fore to really deal with it. We know the links when it comes to domestic violence. This is all interlinked, and we have to have a robust system of investigation, prosecution, and then judicial determination to ensure it can be dealt with.